Yes, we have summer program going on. And one of the things we just had at 825 Golf Drive was a Pistons basketball camp, which we had an overflow of children who were there. We had Pistons ownership who came and directed that camp, and it was very popular amongst the children. So we're happy to use that gymnasium. For the summer programming, we are doing a variety of spots around the city, and we have what we call pop-up locations, so that we know that one of the things is when we used to have 4 centers, it used to be accessible to more children in the community. So we are now have developed a number of pop-up spots. We are negotiating with them to start that programming, including a greatness camp at Trinity Church, including New Bethel Church. We're going to have all-day activities certain days a week, and then as well as New International Church. The 825 Golf Drive, even though the council and their wisdom decided to hold that $2.85 million rather than purchasing that site, rather than getting evicted July 1st, we were lucky that we have a donor who has made it possible that we could also stay on that site long enough to make a successful transition for our children in any homeschooling activities. Okay. Yeah, so I'll have the attorney speak to that, you know, in terms of whether in kind or not. Mr. Gibb, you can speak to that. Yeah. Right.
Council President, members of council, the relationship is between a private donor directly with Dr. Byerly. Dr. Byerly issued legal notification to the city of his intent to preserve his rights under the ongoing lease agreement, but without imposing the penalties that we discussed 2 meetings ago. So we're relying on that communication from him and working, as we indicated 2 weeks ago, to transition the programming. As we indicated, it's a large task so that we continue. We also have contracts for a lot of that programming. So we're doing that work. We're in a very solid legal position regarding 825 Gulf Drive. Economic Development is also working with Dr. Byerly's corporation on the potential redevelopment of that with a private firm. They are also looking at the city to participate in a way that can keep the children's programming going, and all of that is in process. But the city attorney, Attorney Chubb, and myself, now Attorney Bostic, have worked very closely to make sure that the city's protected. There is no impact regarding any of the insurance or the liabilities. The policies of the city remain intact, just as any other programming would be, whether it's there or anywhere else throughout the city.
I know what I'm hearing, but I'm trying to understand, even if there isn't a financial implication on behalf of the city, this obviously was a new contract, right? So even if the financial obligation isn't there, it's a contract with new terms because the old one expired. And how is it that council doesn't have to approve any contracts as it relates to the youth rec program?
Because that's an incorrect legal analysis. It's not a new contract.
How is it not? How's it not?
I didn't interrupt you.
Go ahead.
It's not a new contract, and that's an incorrect legal analysis in landlord-tenant, commercial landlord-tenant law. What's happened is the property owner, the landlord, has provided legal notice to the city that we are technically a holdover tenant under the original contract. It's what we described and discussed over 2 meetings. That landlord has been courteous enough to preserve his rights under the lease, but waive any of the additional penalties. So that contract continues with the city as a holdover tenant at the property. All the remaining obligations remain the same. Our responsibility to provide insurance to staff and for programming activities continues, whether it's there, whether it's at Trinity Church, or whether it's here at the Bowen Center. All of that continues. So there's not a new contract. This is a continuation as a holdover tenant at the property, as is permissible under Michigan law. So the attorneys have made sure that there's been no additional exposure, that our liabilities have not been changed in any way regarding the city's insurance exposure or otherwise. And we're right now in a holdover status. This is something that I advised the council is likely to happen. We've been able to take advantage of a donor working directly with Dr. Byerly and good legal counsel to make sure that we're not exposed any further.
The very nature of the fact that the pay or changed is going to alter the terms of the contract. So even if you're saying to me that someone else is paying, the city, in terms of the contract obligation, is not the responsible party for paying them. Somebody else is paying it.
No, we remain responsible for the entire lease agreement.
So now we're responsible
for the holdover.
But yet
we're
council
not
didn't
paying
approve
that.
that.
We're not paying that on agreement of the landlord. We have no control over what he wants to offer, only to take advantage from the legal. What he's willing to waive or accept under the leasehold contract of the property is what he's willing to waive or accept. So we remain liable, but we've been able to negotiate ourselves into a position that we're transitioning program to churches. We met today with the schools.
Excuse me, Mr.
All the things that you've asked for.
Hold on, Mr. Gibbs.
I just want as quickly as we can.
I just want to stay, because this program is till August 26th via the flyer. So I just want to put that in perspective before you start shifting to talking about moving to churches and other things. The question is this. Almost 3 weeks ago, you guys asked the council to approve a lease extension for Golf Drive. That lease extension did not get approved. Yet still, you guys are still operating out of Golf Drive. The city council has seen no documents in order to continue those services. And so if it's pop up outside, whatever it is, pay those damages, or will we have a special closed session meeting to deal with how we pay for injuries assessed at Golf Drive?
The insurance coverages on the property, including Dr. Byerly's, would continue. And that would be a question of the property liability insurance that he's carrying both as a landlord and our general insurance as a city.
So how can our general insurance be used at a building that is not approved by the council?
Because the council de facto did approve this, because we are a holdover tenant at the property. Now listen, I'm not trying to be argumentative. I'm just saying the legal facts of it. There was no possible way to completely vacate the premises. The landlord has offered to not waive his rights to the lease, but to extend our status as a holdover. We're a holdover tenant at the property. The lease was approved, and that's the status.
Mr. Gibbs, I'm going to turn this over to my colleagues. I'm just trying to get this to make sure I understand. So you're telling me the city of Pontiac is a month-to-month tenant right now? Wow. That's what a holdover is, right? Yeah. You're a month-to-month tenant, right?
Until we vacate or until he files summary proceedings to
amend. And so the question is this. If the city has agreed to take on damages and responsibilities in a building that the contract expired and was not reapproved by the city council, how do you as administration have the ability to continue or enter in any contracts that have not been approved by the city council? When the lease is up, they give you an offer. They say, do you want to renew your lease or do you want to go to month? By agreeing to go to month, that is a new form of contract. I'm just trying to figure out, and maybe it works different in commercial real estate. Right. I'm just trying to figure out how a government body with the city of Pontiac logo on a flyer to August 26th does that without any council approval.
We didn't agree to a new contract, and we didn't agree to go month to month. What we indicated was that the city of Pontiac was not vacating the premises because of the challenges that were described over the last 3 meetings.
Attorney Sharp and then Council.
So at that status, the contract continues. And so
I just want this council to be mindful of the fact that it's public record with the video that council expressed the fact that the city was going to have to vacate the premises. So council did not give the approval to be a holdover tenant. That information is public. So God help us if something happens, because it is public. Council did not make that decision to continue to be a holdover tenant.
And I agree with that. The practical fact is the city attorney, I do agree with that, but the city attorney and I are mitigating the exposed damage to the city. As we indicated, the ability to move and move programming and contracts with the Boys and Girls and all these other things was going to take time, and it's simply taking time. So we've been able to mitigate the damages and the exposure of the city, and we're working as quickly as we can. And we would love to have it go quicker, but we're moving as quickly as we can.
Councilwoman Miller.
I have to calm down, Mr. Gibbs. I'm not going to be so easy here. Mr. Gibbs, you are attorney. You know, I'm just, I can't believe what you're saying to me. My grandchild would comprehend what you're saying is not true. You're operating in a building that I see a flyer. When I see them, like, PYREC, what are you guys doing there? You're supposed to be gone, Mr. I'm calling you Chubb, but sometimes you sound like Chubb to me, Mr. Gibbs. That's not good for me. This is, what if one of those kids over there get hurt tomorrow? And this body, and the first thing people are going to blame is council. Council don't know anything. We look in a Facebook page and see programs over there when we're supposed to be gone. And then you're using the insurance of the people. This is what you call, that's why people don't believe in politicians. We have no knowledge of what you're doing in administration. That's what the residents have to understand. We handle the money, but unfortunately we handle the money, but the mayor and the administration, let's call it what it is, they're doing what they want to do. And if tomorrow one of those kids get hurt over that rec center, then we are going to get sued. And we're already sitting here trying to find money for police officers to take care of the city. This is unethical, unright, and I'm just calling it for what it is. And God help us if anybody get hurt over there. I would like to see the mayor explain herself out of this and you to the residents.
Mr. President.
I can't believe this. She done what she wants.
2 months ago, that we were not going to fill the recreation. You had more than enough time able to get out of that building. Matter of fact, since you here might be a part of the office of Ottawa Power, y'all could have took that stuff
And put it over there.
So as a point of order, that's a defamatory comment, and no, not in 100. I represented the city the same way, Madam Councilwoman, that I'm representing the city in this.
President?
Pro Tem Carter. Yep.
Oh, I thought you shut it off, sorry.
That's right.
But my last 6 months in this state, it ain't gonna happen. I keep up the speed out. And it's like, time out. It is absolutely time out. Thank you very much, Mr. President.
Okay. Pro Tem Carter.
Thank you, Mr. President. I mean, we sit here and hear it over and over again. I was going to say, and to this honorable body, that this is racketeering, this is trespassing, this is pure negligence on the side of the administration. We had already gave up on this piece of property. This is another case for another nail in the coffin to have a forensic audit, because there's exorbitant waste of money going on on the other side. And I think we need to take this directly over to the Attorney General and make it known before any damage occurs. Thank you.
I'm sorry, Councilwoman Waterman. When you said that you were going to cuss and you turned off the microphone for a minute, I thought maybe you're done. I'm sorry. If we have refused this building and we've refused to extend this contract, how is it that you think you can extend the liability on a building that we didn't approve? So who's responsible for that liability? Isn't that us? And we didn't approve it.
The liability on the building itself remains with Creative Management, Dr. Byerly's corporation. The city has.
We didn't okay the contract.
Listen. All I'm trying to do. So I've been accused of things and called a racketeer for the 100th time in this council. And all I'm trying to do is mitigate the exposure of this city on the situation. I recognize the council doesn't want the property. I recognize we have to move. I recognize all of that. What City Attorney Chubb and I are trying to do is to mitigate this, to minimize whatever exposures we do have. And that includes contracts that we have, that includes contracts for programs. All of that's being managed as quickly as possible. United Wholesale is not going to be ready till the fall. We have these other, that's all we're trying to do here. So I know it's angering and I know it's frustrating. Our umbrella policy for the city doesn't change. If somebody gets hurt in that programming at that particular facility, then how it happens and whether it's Dr. Byerly's policy or whether it's our umbrella policy, we'll have to determine that. All I'm doing on behalf of administration and all of you is try to mitigate and move as quickly as we possibly can. That's all I'm trying to do.
Mitigation would be to vacate the premises
Right.
when the lease was up. Yes, Attorney Sharp, and then we're gonna move on.
Problem I'm having with this is, first of all, in terms of, I don't understand how you usurp the council's power and authority. How two attorneys can make a decision to say that they're going to do something different when the power rests with council. Aside from that, I question how many then other contracts are there that council may not have approved, that it was decided upon that to mitigate the damage, they had to do something different. That's a very scary thought. And I just don't understand how this can continue to happen like this. Because it's not right, it's not legal,
We need to go to the Attorney General with this, because if some of those kids get hurt over there tomorrow, we're in trouble. And it's just like you move in my house, I tell you to get out, you stay in, and I'll figure out how I'm gonna get out. But in the meantime, I don't pay you anything. This is what you call total disrespect of this body. It's total disrespect. Here we think, I know when I passed that place, I was seeing cars, but I'm thinking everybody's gone. No, you're there. And you're using our insurance, the city insurance. This is, I refuse, this is too much. This is just too much. And I agree with Councilman Carter. Anything over $10,000, we need to find out what's going on. Think how many other things is going on that we don't know anything about. This is unheard of.
Yeah, Councilwoman Taylor Burks.
I don't know. I passed by there a couple of times, and I'm saying to myself as I'm driving, wonder why do I see these people over here and the place is supposed to be closed? But I kept driving, went home, and took care of it, just forgot about it. But and then after I got home and sat down and started thinking, it dawned on me what was going on. And of course, I got very angry and I said some words that I usually use. And because this is very dangerous and we should not have to put ourselves in that kind of position, because if something goes wrong with one of those kids, we are in deep trouble and we might as well just lock the doors and stay at home. So I think that we should just shut it down. And if anybody tries to open it back up and you see somebody, some kids over there, call the cops, call the sheriff, call anybody, lock them up.
All right, we're gonna take a 5-minute recess and return at 7:20.